Well, sometime when I was a bit younger than I am now, I got called up here to see a bunch of guys wearing black robes and having parts of sheep sitting on top of their heads and things like that. And very dignified forum. I couldn't stop laughing the whole time. Hey, I'm an outsider. They just called me in to explain the meaning of genocide, because I'd written quite a lot on it, published a lot on it, was a recognized expert, so they qualified me as an expert. And I testified, and part of what I submitted was the literal text of the 1948 Convention on Prevention and Punishment of the Crime of Genocide, as well as the chapter out of Axis Rule in occupied Europe that was published by a book published by the Carnegie Endowment for World Peace in 1944, written by Raphael Lemkin. That's the book in which the word is invented, it's coined. So they had the original definition according to the guy who coined the word, and they had the legal definition, the judge. I shouldn't say they. I guess he's a singular person. By the name of McPherson, who I understand is a former law professor, before he ascended to the bench, so supposedly a conversion in the law. He had that, and he had the testimony, and he had corollary testimony from anthropologists on the ground and so forth that were validating in factual terms how it was, the circumstance that had been imposed upon the Lubicons coincided with the definition of genocide in law and also quasi-law. I mean, Raphael Lemkin was also a jurist, so he was writing a legal treatise, actually. You got real clear articulation of the legal definition of genocide. You've got testimony as to the factual circumstances that would give relevance to the term, to the legal articulation. You're in a judicial forum, which is about as legal as you can get, and I was kind of astonished when I read the opinion. It was not totally unexpected, it was just the tenor of it, which was eye-opening to me, since Judge McPherson totally disregarded not only the expert testimony, but the 48 Convention itself, and in fact, ignored the Canadian Implementation Act, because Canada had ratified the Genocide Convention, the 48 Convention, in 1952, even in the late 80s, a little while after 1952, so that law's been on the books in Canada for a while. They ignored all of them. Went to Merriam-Webster's dictionary, and his official opinion was, apparently this is promoting the dictionary definition to the status of binding law in Ontario at this point, that genocide in the popular conception had to be understood only as killing members of a defined or definable group of people. That's not the legal definition. In fact, that's not even a coherent definition. I mean, I used to do political organizing in Chicago. In Chicago, you had something happen in 1929 called the St. Valentine's Day Massacre. It's where Al Capone's machine gunners stood Bugs Moran gang up against the wall, shot all 7 of them to pieces, and walked back out of the Cartage building on North Clark Street. Now that's a defined or definable group of people. The Moran gang is clearly definable. They killed them. That's not genocide, however. No one's ever argued that it was, but by the judge's definition, trying to get out of the actual definition, it could be construed as such. So we had to prosecute Al Capone and machine gun Jack McGurn for the crime of genocide, I suppose. Their only recourse would be the fact that there's never been an articulation of the term at that time. Absurdity. But he goes on in the opinion to enjoin the entire population. I assume this applies only to Ontario, that his jurisdictional standing would only extend to the boundaries of Ontario, but we're all in Ontario, so it's illegal by judicial decree to use the term in any other way. That's the implication of it. Okay? The public is instructed not to use the term in any other sense in popular discourse other than to describe those engaged in the systematic killing of a defined or definable group of people. Well, I'm going to break the law, because I'm going to use it the way the law says. And if they want to arrest have me deported, then okay. But that's more of the complex of denial. And granted, Judge McPherson was not in academia, but he came out of academia into a position of taking his academic competence and using it to rule in a manner that is binding, in principle at least, upon the entire citizenry, which includes university professors, I would assume, in the province of Ontario, within which we find the city of Toronto. And I understand the University of Toronto to be situated inside the city, so it would be in effect here. If your professors, in effect, are teaching you anything like an accurate understanding of crime, they're breaking civil law, at least. Although it could be construed as contempt of court, and if you insist upon it, I think that is a criminal offense. So, yeah, on pain of penalty of law. That's fairly official, is it not? That's denial complex. Usually it's been through a misinterpretation, misarticulation by design in transmission of the idea, usually through educational institutions. So that when the word comes up, whether it's genocide per se, or what comes as something of a synonym, Holocaust, people think immediately of those gates at Auschwitz, and that sign in German said, "Work make you free." Railroad tracks leading in brick buildings, crematory chimneys as a backdrop. You get that image. You're thinking of Auschwitz. Or you could just as well be thinking of Sobibor or Treblinka or any of the other Operation Reinhard camps, the death camps, which are a whole group of facilities separate from concentration camps. That's another conflation they've gotten into, that if you say concentration camp, they immediately say Auschwitz. Auschwitz was not a concentration camp. Or more properly framed, there was a concentration camp at Auschwitz that had a sub-facility, Birkenau. Birkenau is what everybody means by Auschwitz. That's an extermination camp. That's different. Got a whole different chain of command, whole different mission. But you're not supposed to really understand these nuances and distinctions, because in conflations and the muddle that's created, it's easy to deny the obvious is true. There's a third piece to where I'm coming from tonight, and that's a book published in 1993, so right in the middle of the whole thing. Came out Free Press in New York, I think. In any event, it's written by a Judaic scholar named Deborah Lipstadt, who's a senior professor down at Emory University. The title of it is Denying the Holocaust. Subtitle is Growing Assault on Truth and Memory. Now, I really want to recommend it for two reasons. One affirmative and one the opposite. On the affirmative side, the first half of the book is about as lucid an articulation of the techniques, the methods used by neo-Nazi Holocaust deniers to deny the Judeocide perpetrated by the actual Nazis. There's actual technique, there's method to this. All right? And it applies to the denial of any Holocaust. She's laying out the methods. She's talking about a specific group or specific groups, a specific event or chain of circumstances. But the techniques, the methods could apply across the board. Doesn't matter whether you're denying the Armenian genocide or the Cambodian genocide or the genocide right here.